Could I ask you a couple of questions about the separate, I guess it's a separate appeal, the Posse Comitatus Act injunction stay question? And the first is just a factual question.
So to refresh your recollection, Judge Breyer in San Francisco issued 2 injunctions against Trump. One was that Trump's activation, deployment of the National Guard exceeded his authority under this statute, 12406. That temporary restraining order was almost immediately stayed by this court. So suspended, so Trump was able to deploy the National Guard. And when they stayed it, they said, we're specifically focusing on 12406. There may be other arguments that could be made why Trump's deployment of the National Guard is illegitimate, like perhaps he's violating Posse Comitatus. This 3-judge panel said, we're not addressing those legal issues here. We're only addressing 12406. So then Judge Breyer, the trial court, said, oh, they left the door open for me to argue Posse Comitatus. So Judge Breyer immediately issued a second TRO, saying Trump cannot deploy the National Guard in violation of Posse Comitatus. In other words, to use the National Guard for law enforcement purposes. Trump didn't even bother appealing that TRO because it's only stopping him from doing something he's already not doing. He's not using the Guard for law enforcement purposes. But now this Judge Miller wants to ask about that second TRO.
Could I ask you a couple of questions about the separate, I guess it's a separate appeal, the Posse Comitatus Act injunction stay question? And the first is just a factual question. We entered an administrative stay at the beginning of September. Since then, in your view, have any federal forces been engaged in conduct that would have violated the injunction had it not been stayed?
Your Honor, I'm not aware of...
So I have to correct myself. I didn't see that. I didn't see a stay of the Posse Comitatus injunction, but they're saying here they did it. So Trump must have appealed it then. My error. I looked in the docket, but these crazy cases, there's so many filings in the docket, all these amicus briefs. I just missed it. Sorry about that. But obviously Trump did appeal the second TRO, the Posse Comitatus, and they stayed that one as well.
Stayed in conduct that would have violated the injunction had it not been stayed?
Your Honor, I'm not aware of facts one way or the other as to that issue. Defendants have professed an intent to use the Guard for those purposes in Los Angeles, and they've emphasized in their stay papers before the court that there are 2, I believe they're called mobile units, that they have prepared that can be deployed into the field in the types of circumstances that we've challenged in that case. But as far as the current factual state of affairs, I'm just not in a position to address that.
If you were to prevail in what I'll call the principal appeal, the 12406 appeal, I don't know whether it would technically moot the PCA appeal, but would there be much practical significance left to the question?
The PCA appeal is the Posse Comitatus Act appeal.
Of the Posse Comitatus Act injunction?
I believe there would be limited practical significance in terms of formal mootness. It's not something I've given a lot of thought to. I suspect that there may well be, a mootness exception that could apply. We'd have to consider that and give it further thought in light of all of the moving pieces in the National Guard litigation, which has multiplied significantly since the last time we appeared before the court.
Right. And then, I guess one other question on this, which is, what do you understand the injunction, the Posse Comitatus Act injunction, to permit the federalized Guard and other federal military forces to?
Yeah, because Posse Comitatus would only prohibit the federalized National Guard from doing law enforcement functions. They'd still be allowed to protect federal personnel and property, for example.
Because and specifically I'm asking about the last paragraph of the injunction that says, they're prohibited from doing various things except to the extent that there's a valid constitutional or statutory exception, and wasn't clear to me exactly what the order contemplated by that. So what is your understanding of what's allowed?
Your Honor, our understanding is that it allows protection of federal buildings so long as that is not escalated to types of activities that would clearly contravene the Posse Comitatus Act, so detentions and arrests and so forth. But as long as the Guard is deployed merely for the protective purposes at federal buildings, we don't understand Judge Breyer's order to restrict that activity.
And where does,
Although that's not what the last paragraph of the order actually says, right?
I think read in light of the district court's analysis as to this issue, where the court specifically reserves and addresses separately the question of protection of federal property. That's how we understand the injunction.
Although what the order actually says is they're enjoined from, some of what they're enjoined from is instructing, training, or using the guard to execute the laws, including but not limited to things like security patrols, evidence collection, interrogation, or acting as informants. That's what it says, right?
That's my understanding.
So, for example, what does it mean that they are enjoined from interrogation?
Your Honor, I think it restricts the ordinary meaning of the term in interrogation, which is, that's a term that appears in the definition of prohibited Posse Comitatus Act activities in the Department of Defense instruction, DODI 3025.25, which is the longstanding defense
I'm impressed. He pulled that out of his butt. That was pretty good.
department guidance on the scope of the Posse Comitatus Act. So I think you could look there into additional instructional manuals provided by the Defense Department themselves about the meaning of those restrictions, which have been in place for quite a long time.
So, like for evidence collection, if it wouldn't mean that they couldn't pick up a bag of methamphetamine that they saw while they were on patrol?
Your Honor, I confess I'm not in a position. I confess I'm not in a position to answer that precise question today.
Okay.
If I could, Your Honors, with just the.
And by the way, that's fair. That's fair of the lawyer to say. He's here to argue to remove the stay on the 12406 TRO, not to remove the stay on the Posse Comitatus TRO. But of course, the judges are like, listen, we would just like to get this all straightened out now. If we don't address the Posse Comitatus stuff now, we're all back here in a month having the same hearing again.
The remainder of my time turn briefly to the rebellion prong in section 12406.2. We think the court was right in its stay order to focus on section 12406.3, and that's principally because defendants have not put forward a credible understanding of the term rebellion in this litigation. We would respectfully ask the court to consider reaching and rejecting the defendant's interpretation of that term in its opinion here. And the reason.
So the underlying trial court judges, Breyer in San Francisco and Unelected in Oregon, they defined rebellion to mean it only counts if the entirety of the federal government is at risk, which wasn't even the case in the Civil War. But that's the lower court's definition of rebellion. Trump's definition is if people are rebelling against any facet of federal law, like school desegregation, we're allowed to send in the National Guard. That's always been the definition. But of course, California wants this Court of Appeals panel to adopt the lower court's very strained reading of rebellion.
Is that we're continuing to see defendants rely on this interpretation, cases across the country, and we're concerned that the breadth of the definition of rebellion that the government has relied on, which includes on its terms any form of resistance to government laws and policies, which would appear to encompass a range of First Amendment protected speech and protest activities. There's a real risk that when you have senior executive officials discussing that broad definition and threatening to call in the military in response to it, that protected speech activities will be chilled. And so we would ask the court to join the Seventh Circuit in rejecting that view to ensure robust free speech protections continue across the country.
You would concede that there may be more relevant legal determinations coming in the next couple of weeks on the Seventh Circuit case?
There may well be, Your Honor.
That's the Chicago National Guard case.
I think the Supreme Court takes different approaches to the type of emergency procedure.
That's being argued to the Supreme Court. We just covered within the last couple of days, John Sauer, the Solicitor General, Trump's Supreme Court lawyer, filed a memorandum and argument with the Supreme Court, written document that we just covered a couple days ago.
That's now pending.
Are you done?
And then finally, Your Honors, just as to justiciability, again, as I mentioned at the outset, we think the court got it exactly right in holding defendants' actions here subject to judicial review. As the court explained in its stay order, statutory interpretation falls squarely within the ordinary zone of judicial review and the judiciary's responsibilities. We also think it would be exceptionally odd to consider the types of Militia Act determinations here non-justiciable in light of the constitutional and statutory history dating back to the very first Militia Act in 1792, which actually required judicial certifications before the president could invoke aspects of the Militia Act. Of course, that requirement was stricken from the statute, but it's very early founding era evidence that these are exactly the types of.
So it is interesting that Judge Sung, the judge on the right there, is a Biden-appointed judge. And what you often see in oral arguments before the Supreme Court with Justice Sonia, the wise Latina diabetes Sotomayor, and Justice Elena, never been married, never have kids, why do you ask Kagan? And Justice Ketanji, I'm not a biologist, how would I know what a woman is, Jackson? What you often see in those cases is they have been prepared to ask questions of the side, the lawyer for the side they prefer, to elicit favorable statements from their side. But isn't it true that this, and isn't it true that that? So they're extracting from that lawyer statements that would be favorable to the liberal position that Sotomayor or Kagan or Jackson prefer. Judge Sung here is not doing that. In fact, I don't believe she's asked a single question of this California lawyer. It's interesting. And keep in mind, when this 3-judge panel stayed Judge Breyer's underlying TRO against Trump, when they froze that, it was unanimous. All 3 of them voted to freeze that TRO, including Sung.
Questions that our founding fathers considered to fall within the cognizance of the Article 3 judicial power. If the court has...
Well,
finally.
How we were dividing time between the 12406 appeal and the motion for a stay of the permanent injunction on the PCA ultra vires cause of action. So if we're combining them, I may have another question on that because most of the focus has been on the 12406 issues. On the PCA, do you have a response to the defendant's argument about the willfulness element?
I do, Your Honor. We acknowledge that the willfulness requirement appears in the text of the PCA. We don't think it's especially relevant to an assessment in this posture where we're seeking only prospective injunctive relief because, as I understand defendants' argument on this score, it's that their conduct wasn't willful not because it wasn't intentional, it was directed by high-ranking officials, but because there was a misunderstanding of the scope of what the PCA limits. But on a going forward basis, there will be no such confusion because the law has been clarified by Judge Breyer's opinion and presumably by an opinion reaching the merits from this court. So any violations would necessarily be willful because they would understand the legal requirements going forward.
It's a little tricky, though, because your ultra vires argument is premised on the existing violation, that a violation have occurred.
I think as a formal matter, Your Honor, we're arguing.
So ultra vires is a claim the left likes to make because it's so ambiguous. Ultra vires literally means beyond the law. And it's grounds for restraining the executive branch. If the executive branch is doing things that are in violation of a statute over which Congress has authority, you're breaking the law. The president can't just break the law, or it's simply clearly exceeding the Article 2 executive branch authority. So, for example, if President Trump issued an executive order telling the Supreme Court how to rule on a decision, that would be ultra vires. That's clearly beyond the Article 2 executive branch authority of the president. Or if Trump told Congress how to write a bill or how to vote on a bill, that would be ultra vires. But it needs to be something that extreme. And there's nothing that Trump's doing that falls outside those very broad boundaries. He's acting within the plain language of a statutory delegation of militia authority from Congress. He's not violating any provision of that statute because the statute doesn't have any prohibitions in it for him to violate. So the whole ultra vires argument is just silly here. You know who's acting ultra vires? These judges. These unelected black robe tyrannical inferior district trial court judges are acting ultra vires in claiming a veto power over the commander-in-chief exercise of the militia authority delegated to him by Congress.
That there is a
Boy, it would be nice if the Trump lawyer made that. I assume he gets an opportunity at rebuttal. It would be nice if the Trump lawyer made that argument. It's a little in your face, but he could say it's not you guys being ultra vires, but it's these unelected black robe tyrannical inferior district trial court judges. It's our position they're acting ultra vires, Your Honors.
sufficient risk of future violations to justify ultra vires injunctive relief. And the past violations, whether or not they satisfy the willfulness requirement, although we think they do for the reasons provided by the district court, the activities show, violating the substantive terms of the PCA, show a sufficient likelihood of, to put it another way, Your Honor, if you agree with everything about our PCA arguments except for the willfulness issue, just assuming that for sake of argument, then the willfulness issue would not be a barrier to granting prospective injunctive relief because that falls away on a going forward basis. There's a sufficient likelihood of recurring violations.
And do you have any authority for that proposition?
Your Honor, in our motion, we relied on common sense. We also pointed by analogy to the en banc decision in Dreyer, which was somewhat similar. It wasn't injunctive relief, but it was looking to prospective, the issue of prospective violations enforceable through suppression motions in criminal cases. So that, again, first of all, shows that the PCA has been deemed enforceable outside of criminal charges brought under the Posse Comitatus Act. And it also...
But you concede, counsel, as the United States argues, that you haven't cited a case, nor are you aware of one, in which any government has been enjoined or the federal government has been enjoined from enforcing based on a criminal statute.
No, Your Honor, we disagree. That there are a range of cases. We cite to an example from the D.C. Circuit in our brief where criminal statutes have been enforced civilly through the Administrative Procedure Act. I certainly acknowledge this isn't an Administrative Procedure Act suit, although we do have a claim on that basis preserved in our complaint. But our point is...
Has there ever been an injunction?
Yes, under the APA.
Involving a criminal statute?
Yes.
And what was the nature of the injunction?
It was an injunction to enforce the Criminal Trade Secrets Act, which the Supreme Court in the Chrysler decision held is enforceable civilly, even though it's a criminal statute, through the Administrative Procedure Act. And courts, I think on a fairly regular basis, grant injunctive relief under the APA to enforce that criminal provision. And our point here, even though this isn't an APA suit, it's an ultra vires suit, is if the Supreme Court hasn't been willing to draw the categorical per se line that defendants request between criminal and civil enforcement in the APA context, we see no reason to draw that categorical line when it comes to an ultra vires cause of action like ours.
You agree that we are bound by the statement in the NRC case where the court said this type of claim is essentially a Hail Mary pass, and in court, as in football, the attempt rarely succeeds?
He's talking about ultra vires claims as a Hail Mary pass, and quite right.
We agree that you're bound by the decision, of course, but we don't think the decision applies in the circumstances here, because for two reasons. NRC was a case where it was an ultra vires claim in a case where there was an express statute there, the Hobbs Act, imposing limits on review and precluding review. And so what you had was Texas, the plaintiff there, was trying to circumvent express limits on review under the Hobbs Act by simply styling its claim as an ultra vires claim. We don't have that here. The federal government has not pointed to any express limitations on the ability to bring an ultra vires action enforcing the Posse Comitatus Act. Another important dimension is that the claim in NRC was purely statutory. But as the en banc court made clear in the Dreyer decision, the Posse Comitatus Act is no ordinary statute. It's a statute with an important constitutional dimension. And under this court's precedent in Murphy versus Biden, ultra vires claims are broadly available when a statute has constitutional implications.
I think that NRC, you argue in your briefing, even assuming in the NRC standard applies here.
The Hail
I
Mary.
understand your argument as to why it does not, that the standard has been met. I think NRC seems to identify two requirements, at least. One is the attempted exercise of power specifically withheld or specifically prohibited, and no other avenue for judicial relief. Can you address those two requirements?
Yes, Your Honor, on the assumption that, of course, that NRC is applicable, which we disagree with. I mean, for the reasons provided by the district court, we think that restrictions in the PCA are clear and binding and were plainly violated here on a widespread basis. And as to the availability of another action for judicial review, I want to be somewhat careful on this because we do have the APA alternative preserved in our complaint. We haven't moved on that to date. To the extent the court agreed that the APA provides an avenue for review, that may present a challenge on that second prong of NRC. But assuming the APA does not provide a basis for review, then I think that would be satisfied because there would be no other way to enforce the PCA in these circumstances. And just quickly on the Administrative Procedure Act issue, I know that in general it can feel a little odd to think about enforcement of the APA in a context like this one involving military orders, but the text of the APA actually expressly defines agency action subject to review to include exercises of military authority except in the field of conflict in a time of war, which plainly would not fall into. Again, we haven't moved on our APA claim to date, but just for the court's awareness, to the extent it considers that issue in evaluating the ultra vires cause of action.
Okay, can you just briefly address the why isn't 12406 a exception to the PCA? I mean, it says the president can call members of the Guard in such numbers as he considers necessary to execute the laws. How do we make sense of that if what they're doing is not executing the laws?
Because the Posse Comitatus Act, as we understand and as courts have interpreted it, does not bar every form of law execution. It bars the execute the laws clause in the Posse Comitatus Act should be read in light of the clause forbidding actions as a Posse Comitatus. So the historic policing related activity performed by citizens in support of a local sheriff or constable, the way that's generally been understood is to bar law enforcement actions of the sort that police generally execute. So things like search and seizure and interrogation, evidence collection, brandishing a weapon, and as the Department of Defense has explained, things like security patrols and crowd control, traffic control, the sorts of things that the Guard has been doing on a widespread basis.
Counsel, to go to ask another question like Judge Miller's question. Even if your view, California's view, were arguable, given the standard for ultra vires relief, I'm having a hard time seeing how the exception in 12406 to execute the laws wouldn't count as an exception under the PCA in an act of Congress, at least to the extent that there's enough ambiguity that this couldn't possibly be ultra vires. I mean, I understand your argument, but for me, I don't see it as nearly clear enough to justify ultra vires relief, given the language that Judge Miller cited that obviously is in the statute. Why am I wrong?
Your Honor, I certainly want to acknowledge that if you're going to apply that Hail Mary standard from NRC, that makes it a much harder case for us in terms of the availability of ultra vires relief. I do want to underscore, though, we have, I think, very powerful arguments that NRC was not addressing circumstances like those at issue here. And this court had very clear pre-NRC precedent. The Murphy versus Biden case is the main one we have relied on, that takes a broad view of the availability of ultra vires relief. And so that decision would be binding on this panel unless NRC clearly abrogated it. And I don't think that standard is satisfied. As to the question about, again, why 12406 does not constitute an exception to the PCA, the exception has to be expressed under the PCA's plain terms. And as we read the PCA, it doesn't bar all law execution, all forms of law execution. And so that 12406 is authorizing law execution in general. It's not authorizing the specific types of law enforcement activities that would fall within the Posse Comitatus Act scope.